of TCC Judgment 113 Champagne 8, 2024, the constitutionality of death penalty case. High notes. Mandatory death penalty for homicide during extortionate kidnapping without consideration of circumstances is unconstitutional. Death penalty for homicide, homicide during rape and aggravated rape, homicide during robbery, and homicide during extortionate kidnapping under the Criminal Code, hereinafter the Code, is constitutional if applied in the most serious cases and conform with the strictest requirements of due process in criminal procedures. Specific procedural safeguards are required for the offenses above. 1. Mandatory counsel during criminal investigation and on final appeal. 2. Mandatory oral arguments on final appeal. And 3. A unanimous decision by the collegial panel of professional judges for death sentences. The Taiwan Constitutional Court (TCC) specifies several extra procedural safeguards for defendants with mental conditions, disorders, or deficiencies in the cases in question. 1. The death penalty will not be imposed if an individual's mental condition significantly reduces their ability to make judgments at the time of the offense or render them incompetent to stand trial. 2. Inmates shall not be executed if their mental conditions impede their competency for execution. Background note. In Taiwan, about 50 provisions in several separate criminal statutory laws stipulate capital punishment as the maximum punishment. Under the Code, the maximum punishment for certain crimes, e.g., homicide, homicide during robbery, rape, and homicide during extortionate kidnapping, is the death penalty. The TCC has formally upheld the constitutionality of the death penalty applicable under special criminal law provisions in JY Interpretation 194, 263, and 476. Years after the announcement of the interpretation number 476, the question of whether the death penalty is constitutional, and if so, what are the substantive and procedural requirements, arises again upon the petitions filed by the petitioner in this case. Insofar as there are 37 death row inmates in Taiwan, all of them are petitioners in this case. The petitioners were found guilty of at least one of the following 4 crimes. 1. Homicide, offense of Article 271, Paragraph 1 of the Code. 2. Homicide during rape and aggravated rape, offense under the first clause of Article 226-1 of the Code. 3. Homicide during a robbery, offense of Article 332, Paragraph 1 of the Code. And 4. Homicide during kidnapping for ransom, offense of Article 348, Paragraph 1 of the Code, both the current and April 21, 1999 version. The petitioners were all found guilty and sentenced to death in their respective final court decisions between 2000 and 2020. After exhausting all ordinary judicial remedies, the petitioners filed for constitutional reviews respectively. They argue mainly that 1. The punishment of the death penalty or mandatory death penalty applicable under the said criminal provisions that they were found guilty of was unconstitutional for violating their right to life. 2. The criminal procedures they underwent violated the due process of law, as such procedures had left them without effective assistance of counsel and the proper oral argument during their last appeal. And 3. Article 19, Paragraph 2 of the Code was unconstitutional insofar as it did not prohibit death penalty from being sentenced or executed on those defendants with mental disorders. The petitioners' cases were consolidated and argued on April 23, 2024. Summary of the judgment holding. 1. Article 271, paragraph 1 of the Code, hereinafter provision 1, stipulates a person who takes the life of another shall be sentenced to death or life imprisonment or imprisonment for not less than 10 years. The first clause of Article 226-1 of the Code, hereinafter provision 2, stipulates a person who commits the offense specified in Article 221, 222, and intentionally kills the victims shall be sentenced to death or life imprisonment. Article 332, paragraph 1 of the Code, hereinafter provision 3, stipulates a person who commits robbery and intentionally kills another shall be sentenced to death or life imprisonment. Article 348, paragraph 1 of the Code, hereinafter provision 4, stipulates a person who commits an offense specified in paragraph 1 of the preceding article and intentionally kills his victim shall be sentenced to death or life imprisonment. Intentional homicide under said provision is the most serious offense against the person's right to life, which may be punished most severely to the extent of the death penalty. However, the death penalty must be applied to cases with the most serious circumstances and conform to the strictest requirements of due process. Within this scope, the said provisions do not violate the right to life enshrined in the Constitution. The April 2, 1999 version of Article 348, paragraph 1 of the Code, hereinafter provision 5, which stipulated a person who commits an offense specified in paragraph 1 of the preceding article and intentionally kills his victim shall be sentenced to death, violates the constitutional principle of non pena sine culpa, because it fails to distinguish whether the circumstances invoking the mandatory death penalty are the gravest. Within this scope, the provision does not conform to the right to life under the Constitution. 3. A person suspected of committing the offense in Part 1 of the holding shall be represented by a legal counsel when questioned and examined. The Code of Criminal Procedure, hereinafter COCP, is unconstitutional insofar as it lacks relevant provision requiring so. It contravenes the constitutional protection of the right to life, the defendant's right of defense, and the due process of law. Authorities concerned shall amend relevant provisions following this judgment within a 2-year grace period. If the amendment is past due, investigation shall be conducted in the manner required by the judgment. However, the concluded investigation remains valid and unaffected. 4th, mandatory counsel should apply to final appeals for provisions 1 to 4 cases. Such application is not required in Article 3AA of COCP, hereinafter provision 6, which provides that Article 31 does not apply to a trial of third instance. Within this scope, the provisions contravenes the constitutional protection of the right to life, the defendant's right of defense, and the due process of law. The said provision shall cease to be effective upon the announcement of this judgment. Authority concerned shall amend relevant provisions following this judgment within a 2-year grace period. Courts of final appeal, third instance, shall immediately apply mandatory counsel when hearing provisions 1 to 4 cases. 5. Regarding provisions 1 to 4 cases, oral argument shall be required for the Court of Final Appeal to hand down a death penalty or to uphold lower court's death penalty decision. Such a requirement is not provided in Article 3A9. Paragraph 1 of the COCP, which stipulates the Court of third instance may be trial without oral argument, provided that the court may order argument if necessary. Within this scope, the provision contravenes the constitutional protection of the right to life, the defendant's right of defense, and the due process of law. Authority concerned shall amend relevant provisions following this judgment within a 2-year grace period. Courts of Final Appeal shall try with oral argument when hearing the cases in question immediately. The death penalty must be imposed only by a unanimous decision from a collegial panel of professional judges. The Court Organization Act does not specify so for provisions 1 to 4 cases, which contravenes the constitutional protection of the people's right to life and the due process of law. Authority concerned shall amend relevant provision following this judgment within a 2-year grace period. The court at all levels shall apply such requirements immediately. However, the effectiveness of a previous decision made before this judgment shall not be affected. 7. To conform to the constitutional principle of non pena sine culpa, this penalty must not be imposed if the defendant at the time of offense was in the circumstances described in Article 19, Paragraph 2 of the COCP. Hereinafter Provision Act, which is a significant decrease in the ability to perceive the illegality of an act or to act accordingly due to mental impairment. The authority concerned shall amend relevant provisions within a 2-year grace period. Before the amendment, the death penalty shall not be rendered in cases with such conditions as to conform with the constitutional guarantee of the right to life, the defendant's right of defense, and the due process of law. To conform with the constitutional guarantee of the right to life, the defendant's right of defense, and the due process of law. The courts shall not sentence the defendants of provision 1 to 4 cases to death if they had mental conditions that clearly diminish their ability to defend themselves in court. The authority concerned shall amend relevant provisions within a 2-year grace period. Before the amendment, the death penalty shall not be rendered in cases with such conditions. 9. The laws sentenced to death in provision 1 to 4 cases shall not be executed if they have mental conditions that impede their competency for execution. The COCP and the Prison Act violate the constitutional guarantee of the right to life and the due process of law, insofar as it lacks provisions prohibiting such inmates from being executed. The authority concerned shall amend relevant provisions as appropriate within a 2-year grace period. Before the amendment, the death penalty shall not be rendered in cases with such condition. 10. All petitioners sentenced to death may file for extraordinary appeal with the Prosecutor General if their cases were not the most serious. The Prosecutor General may also lodge an extraordinary appeal as ex officio for such cases. 11. Petitioner number 3637 may file an extraordinary appeal with the Prosecutor General for their final court decision. Supreme Court Criminal Judgment 89 Taishan 2196. The prosecutor general may also lodge an extraordinary appeal ex officio. After revoking their decision, the Supreme Court shall apply provision 4 in accordance with this judgment. 12. All petitioner may file for extraordinary appeal with the prosecutor general for the part in which Article 3AA, 3A9, paragraph 1 of the COCP, which were applied in their final court decisions, violated the Part 405 of the holding. The prosecutor general may also lodge an extraordinary appeal ex officio. The petitioner may not lodge such an appeal if their final court decision had undergone oral argument and had been assisted by defense counsel. 13. Petitioners may file an extraordinary appeal with the prosecutor general if the deliberation on the Court Organization Act resulting in their sentence did not comply with Part 6 of the holding, unless there is a proof that their decision was rendered unanimously by a collegial panel. The petitioners may file for extraordinary with the prosecutor general, or the prosecutor general may file one ex officio. 14. The legal provisions apply in the final court decision of petitioner number 12 and 13 and 14 did not conform with the Part 8 of the holding. They shall not be executed before the concerned authority amend relevant laws as appropriate. After the amendment, the petitioner may file an extraordinary appeal with the prosecutor general, or the prosecutor general may file one ex officio. When Supreme Court revoke those original decision on extraordinary appeal, detention in the remitted cases shall be handled by respective competent courts according to relevant procedure. The number of times and the duration of detention specified in Article 5, paragraph 2 to 4 of the Criminal Speedy Trial Act and the 8-year period specified in Article 6 of the same Act shall be recalculated from the revocation of the original decision under Article 447 of the COCP. The remaining parts of the petition shall be dismissed. Preliminary injunction applications shall all be rejected